Everything you say, you got that feedback here. Is somebody's laptop on?
It looks like you have two laptops connected to the audio, so you need to disconnect one.
Can you hear us?
Yes, we can.
Can you hear us?
We can't. Yes, we can.
We can't hear them. Can you hear us now?
We can hear you. Can you hear us?
Now I can hear you. Yes.
Great. I think we just need to have your camera on, Mr. Leventhal and Mr. Kamens. Great, perfect.
Okay, good morning, everybody. Before we begin, the respondent has filed a memo of legal arguments on his behalf this morning. We obviously haven't had time to read it. We will take it and we will look at it after we adjourn following the oral arguments this morning. So there's really no need to discuss it unless Mr. Fox, if you want to address it, but otherwise, I don't think it's necessary to go into it. Respondent insists that's your right to do it. I'm not going to preclude you from doing that. This argument this morning is really pursuant to Board Rule 11.11, where the hearing committee is contemplating whether it can conclude that disciplinary counsel has proven a violation of any of the charged disciplinary rule, preliminarily decide. And the oral argument, I think, will be helpful in making that determination. So that's why we're here this morning, and we'll discuss how the facts bear on the various the charges that are issued in this case, 3.1 and 8.4D. So, Mr. Fox, I'll give you the floor at this point, but before you begin, I just want to make an observation that I think may help guide your argument a bit, and it deals with both charges, but we need to know specifically what the charges are based on and what claims they're based on, because we come to this relate to this case, and there are, it seems to me, 4 or 5 possibilities here. One is the initial complaint, which was filed in the case, and of course that was superseded by an amended complaint, and that seemed to me to raise an issue here as to whether that can underlie the 3.1 charge. Then there is an amended complaint, and there is some question whether Mr. Giuliani is responsible for that amended complaint, because he said that he did not participate in the revisions. And the amended complaint also withdrew some of the claims that were in the initial complaint. The third possibility here is the second amendment complaint, but that was never accepted for filing. So I think that raises a question as to whether 3.1 could be based on that. And then there's the oral argument before Judge Brand, some of which was discussed, and I must say that in that context, in my view, there's some room for rhetorical hyperbole in oral arguments. And I wish, if you're going to base the claim on the oral argument, I wish you could address that issue. And finally, the Third Circuit appeal, and I don't know if the brief, even if the briefs are in the record, but whether or not the claims made in the appeal underlie the 3.1 claims. So I just wanted to get that out of the table before we begin, and hopefully you can address some of those issues as we go along.
All right, thank you, Mr. Chair. And actually, let me turn to that initially. I will say that I have not read the document that Mr. Leventhal put forth this morning, so I don't intend to comment on that. But let me talk about the source of the 3.1, which I don't really think is an accurate statement of the issue. First of all, we're not contending anything based on the Third Circuit appeal. But what the rule says is that a lawyer shall not bring or defend a proceeding or assert or controvert an issue therein, unless there's a non-frivolous basis in fact in law. It seems to me that Mr. Giuliani's conduct is encapsulated in the documents to which and the advocacy that he had personal responsibility for. Some of that was the first complaint, which was withdrawn. Some of that was which was amended. Some of that was the oral argument, and some of that was in the Second Amendment complaint. But the focus that I would make primarily would be on the oral argument and the Second Amendment complaint. And I should say that, and we'll probably do this for you in the post-hearing briefs, but if you do a paragraph by paragraph comparison of the initial complaint and the Second Amendment complaint, you'll see there's very little difference between them. Actually, a couple of the factual statements in the first initial complaint were withdrawn. There were a few additional facts that were stated. There was a little more sharpening of the rhetoric. But I think the advocacy that we fault Mr. Giuliani on is for his argument before Judge Brand and the subsequent Second Amendment complaint. And the fact that it wasn't accepted because he had no basis for it, according to Judge Brand, doesn't seem to me to be a factor in mitigation. It seems to me to be a factor in aggravation. So having said that, let me turn to what I wanted to say initially, which is that elections for federal office in this country are conducted by the states and to some extent the localities. Now, there would have been absolutely nothing improper about the Trump campaign or the Biden campaign or anybody filing an action in state court challenging some of the procedures that were going to be put into place when this new act, Act 77, was first enforced in the general election. Indeed, that happened. As we reviewed with you, there were a number of litigations to flesh out what that act meant. Nothing wrong with that whatsoever. Some of those actions were brought, I don't know how much, whether they were brought by the Republican Party. I know some were brought by the Secretary of State herself, but that's perfectly legitimate to bring those and get those rulings in state court. It's equally legitimate, it seems to me, in the election, on election day, if an issue arises about the barriers in the context of trying to conduct an investigation, conduct an election for the first time in the middle of a pandemic, with many more mail-in ballots to count, how precisely one balances the need to protect people from the virus, and nevertheless carry out their responsibilities. Observers perfectly responsible to bring that issue forth to the state court because it's a state issue and it should be resolved. Indeed, Bush v. Gore was a state case initially. It was it got a lot of procedural tails to it, but initially it was a recount case in an election in Florida that was decided by something like 500 votes. And they filed for a recount, and that led to if you look at Bush v. Gore, the Supreme Court case, you'll see it's a writ of certiorari to the Supreme Court of Florida. That was a state court case.
Was there any effort to petition for cert in Pennsylvania in the Trump case?
I don't think so. That one of the pre-election challenges did result in some action before the Supreme Court. And certainly that case, and I'm drawing a blank on the name, that Mr. Ortiz testified about yesterday, and that it was brought up, I think, earlier in Mr. Giuliani's testimony. That case went to the Supreme Court, not the Bachmeier case, but a kind of related case. But aside from that, I don't believe any of the other cases that went to the Supreme Court.
One other question. Was there
I'm sorry, I'm not quite hearing you, Mr. Bernius. I apologize.
Was there an equal protection or due process claim raised in the Pennsylvania state courts?
I do not believe so, but I'm subject to check on that, but I do not believe so. Why weren't there state court cases? Well, Mr. Giuliani testified, I think, candidly in this regard. He didn't think they'd get very far out of the state. So they brought these federal cases. Now, let me just say this before I launch into where I want to talk
Mr.
about.
Fox, can I just ask, talking about the state court, what do you make, if anything, that the procedures for an expedited review of these voting matters was not pursued?
Well, I think it's a telling fact in the sense that, and as I was actually going to go to this next, the purpose of litigation was probably not so much to get the issues resolved. It was to file a case, part of a larger action to sort of discredit the results of the 2020 election. Filing a case in state court using the expedited proceedings would have gotten a decision on the merits, perhaps, and perhaps rather quickly, but that doesn't seem to be the goal of the plaintiffs in this matter. When Mr. Giuliani left the White House on what he said was probably November 4, he went with a determination to file an action in federal court to change the results of the election. I mean, he's testified that his ultimate goal was to combine a bunch of these cases. The chair used the phrase multi-district litigation. I'm not sure that's quite what it was, but to combine them in some fashion and to get the matter in front of the Supreme Court. They took a shoot first, ask questions later approach. It was a litigation in search of facts and theory. So, and you can see that in the evidence. We've put into evidence a deposition that's Rule 34. There isn't going to put up parts of it, but it's really scattered over several pages and it doesn't work very well. But what Mr. Giuliani said there, and he really said it in his testimony the other day, was he leaves the White House, he goes to the campaign headquarters. Where are the complaints? You know, why aren't we ready to go? Well, you know, the election just happened. What are the facts to base the complaints on? They you know, nobody knows at this point. But the point is to file a complaint. Where are the lawsuits? And I think the testimony makes clear that that's what they were doing. They were going to file a complaint, and let's find the facts and let's find the theory. Look at Mr. Carrick's testimony. And Mr. Carrick, as I understood it, was the chief investigator. Now, I think it says something about the integrity of this investigation that you hire a guy with multiple felony convictions. Nevertheless, he's going to run the investigation. And he was looking for facts. And he pretty candidly told you that. So he comes up with a list of voters who are over the age of 112. The first one on the list is purportedly 166 years old. Now,
okay.
I'm sorry, somebody in the respondent side is talking during.
Oh, I think
You guys have, you're having interference because you have all three of your computers hooked up to audio. You need to disconnect two of them. So we're not hearing.
Objection, I didn't hear a ruling, that's why I went unmuted my, when he said multiple convictions. Do you hear me now? Hello?
We can barely hear you because you're using Mr. Giuliani's computer.
Can you give me 1 second? I'll try to make a better.
I'm not sure what's going on now.
I'm not either.
You're all on mute. You need to disconnect two of your laptop's audio, like yesterday's setup, so we can hear you.
Can I be heard now?
Sure. What?
It can be heard?
What do you?
Well, I just
Hello?
wanted to see if you could hear me. I had raised an objection, no one responded earlier.
What's your objection?
When he said multiple convictions.
You can respond to that in your argument, Mr.
Okay. All right, thank you, sorry.
Okay, I'm sort of lost my train of thought here, but okay, Mr. Carrick, he comes with a list of voters who are over the age of 112, and the first one's 166 years old. Now, right in their own files, in their own documents, there are exhibits that show that these records are not accurate, that these voting records of this regard in the state of Pennsylvania are not accurate. Could we put up exhibit 20 DX24 at page 162? This is a declaration that was in the files of one of the law firms that provided it. From a woman whose name is Pinkerton. She says she's the district manager of one of the congressmen, and that she has to use a state database known as RepNet. And she goes on in paragraph 11 to point out how inaccurate it is and that frequently dates of birth are wrong. They knew that. That's in their files, their evidence, but they're looking for facts to try to support their theory. Mr. Carey comes up with the astounding fact that out of the 7 million people who voted in Pennsylvania and the 5 million people who voted in Georgia, some of them, a substantial number of them, maybe 200,000, have the same names. I mean, they're just looking for stuff. Mr. Droz, the somewhat eccentric gentleman who testified that somebody contacted him and asked him in 2 days if he can come up with some statistical stuff. It's a litigation looking for factual support.
Mr. Fox, on the Georgia/Pennsylvania voter lists, was there any identifying information on those two separate lists other than names? I mean, were there? So that was it. It was just
their addresses, but nothing like social security numbers or anything like that.
And I just that the addresses of Joe Jones in Georgia was a Georgia address, and the address of Joe Jones in Pennsylvania was a Pennsylvania address.
That's right.
Oh.
Now, and they're not quite as generic as Joe Jones, but they're pretty generic. Mr. Giuliani testified that you don't plead evidence, you plead allegations. Well, no, you don't plead allegations. Allegations have to have some basis.
Yeah, said that.
Mr. Giuliani, can you mute your mic, please?
Yeah, I'm sorry.
Thank you.
On my mind. We're right next to each other. I'm sorry. Go ahead.
And the allegations have to have some basis in fact. And under Rule 3.1, there has to be a factual basis. That's what it says. You don't just plead allegations if you don't have the facts to back them up.
So, Mr. Fox, how does that jive with discovery? Where does discovery come into play?
Well, discovery certainly allows you to flesh out the allegations and the facts of the complaint, no question about it. But it doesn't give you the right to just sue with no factual basis. Let me give you an example. Let's suppose, and this actually happened to me the last year or so, somebody vandalized my car parked on the street next to my house. Well, I got a cause of action there, and, you know, perfectly legitimate cause of action if I knew who did it. But I can't just accuse my next door neighbor of doing it without any factual basis and say I'll flesh it out in discovery. I've got to have some basis for doing it. Otherwise, you can go around suing anybody for anything without any factual basis. You don't have to have all the facts, but you got to have something.
Mr. Fox, let me, and again, I apologize for my confusion, but there was an elections clause claim raised, and that seems to have at some point disappeared from the case. And then there's a due process claim and an equal protection claim. And it's my sense is that the equal protection claim was based on simple fact that some counties allowed notice of cure and other counties didn't. And that the due process claim is based on simple fact that we weren't allowed to see we couldn't see the ballots as they were being opened and counted. So in terms of the operative claims, it looks to me like there was an adequate basis in fact. Then there's a lot of other stuff that's thrown in for kind of window dressing. And so what is the 3.1 violation based on? And if I'm wrong in that perception, correct me.
Well, the where I was going to eventually get to after I sort of and I'll get there faster in light of your question, but where I was eventually going to get to it in attempting to show the absence of any facts was that you were driven to those two things, and I agree with you. It is a fact that some of the counties afforded their voters the notice and cure, and it is a fact that there were, provisions put in place because of the pandemic to isolate people from one another. Those two things are the facts, but those facts don't support the allegations that were made. I will put aside going through all the other facts that don't exist, but there's, Mr. Giuliani made a lot of statements in the course of this proceeding that just have no factual support whatsoever. But let me go to the only two facts that they had. Okay, that the notice and cure was not permitted. The notice and cure and the observational restrictions. Okay. Those are perfectly appropriate issues to litigate before the appropriate state forum. If in fact, there's a basis to challenge them. For example, it is clear from the statement that Mr. Leventhal made earlier in these proceedings that they take the legal position that when the Pennsylvania Supreme Court said that the counties were not required to have a notice and cure procedure, and they said that we as the judiciary are not going to make that decision that whether they're required to do it, it's better left to the legislature. He's got an argument that says, well, therefore the counties weren't allowed to do it. Perfectly legitimate argument to raise in front of the state. It's a state court issue. What is Act 7? You raise it in front of the state. You do it before the election. You say, okay, we interpret this opinion from the Pennsylvania Supreme Court to mean the counties are not even allowed to do it. And you hash that out in front of the appropriate forum. This is the Supreme Court of Pennsylvania, ultimately. Nothing wrong with that, but that's not what they did. The same thing with observational restrictions. There's nothing wrong with bringing the case that in Philadelphia that was brought in the state court. to say, you know, we're not complying. These observational things are interfering with the observers, and let the state courts in Pennsylvania hash it out. I mean, it's their law about the fact that they have to have observers there. There's no federal requirement that there be observers there. It's their law about it. What does it mean to observe? Are these barriers consistent with what observation means in Pennsylvania? Very legitimate issue to raise in front of the state. But it doesn't constitute a Section 1983 action. A Section 1983 action is an action, it's a civil rights statute. It's an action, the predicate for a 1983 action is that a citizen has to be deprived of his right under the US Constitution or under federal law. That's what a 1983 action is. It's more than citizens, but since we're talking about the right to vote, I think we can just restrict it to citizens right now. And it's a post-Civil War statute designed to protect voting rights in part. I mean, a lot of these post-Civil War statutes were enacted in the era of Reconstruction to permit the newly emancipated freedmen to vote, to prevent the authorities from interfering with it. The notion that somehow or other you take that and turn it on its end and try to use it to prevent people's vote from being counted is more than bizarre. There's no federal law that says anything about whether you have to have or can or cannot have a notice and cure practice. There's no federal law that says anything about observational barriers and what they would be in a pandemic. And if I could just pause parenthetically on this, when Mr. Giuliani was describing this nationwide conspiracy to interfere with the Republicans, he keeps saying, we found in state after state, they had these observational barriers. Well, it's a pandemic. People were dying. There weren't vaccines at the time. And of course, every state is going to come up with some way to try to protect their election workers and their voters at the time. It's not evidence of a conspiracy. It's evidence that it was a rational thing to do in the context of a pandemic. And this is the way they take things and turn that into a civil rights violation. Now, the only way these things could possibly be a civil rights violation is if somehow they allowed such a massive fraud that they denied, you know, other.
Could you please mute your microphone, Mr. Giuliani?
Mute my microphone.
It's Mr. Giuliani's camera that his mic's still on. Can you mute it on your computer? Thank you.
The only way that these things could possibly deprive anybody of their right to vote is if they resulted in such a massive fraud that the voters of Pennsylvania's votes were not, you know, counted accurately. That's the only way it could happen. And maybe that would be a federal violation. But that's not what happened. Look, notice and cure doesn't prevent people from voting. It doesn't prevent your vote from being counted. It enhances the opportunity to count your vote. That's the whole purpose. If you know, you got a new procedure here, people are going to mess it up. They're human beings. We all do it. They mess it up. So it's giving them the opportunity of a legitimate voter who tried to vote mail in and mess it up somehow. It's given him the opportunity, him or her, the opportunity to have their vote counted. It's not a civil rights violation. If anything, it enhances the right to vote. And the observational barriers are not fraud in and of themselves. They're not even circumstantial evidence of fraud, despite Mr. Giuliani's somewhat bizarre interpretation of circumstantial evidence. At best, they afforded somebody the opportunity to commit fraud. But there's no evidence that anybody did. There's no evidence that any vote was improperly counted. None. And just to pause for a moment and think about this, this fraud claim presumes that all those good citizens in Philadelphia and Pittsburgh and I guess the other 5 counties who went down to the polls to work as election workers on election day, risking their health in the middle of a pandemic, were actually all part of a massive conspiracy who were miscounting the votes because people were buying observational barriers and couldn't see what they're doing. And there's just no evidence of that. And certainly one of those persons would have, would have disclosed it if it had happened. And indeed, look at the evidence. I mean, Mr. Giuliani says, "Oh, there's a terrible Democratic machine in Philadelphia, notoriously corrupt." There is any evidence. It's ironically, it's an exhibit in Mr. Giuliani's pleadings, Exhibit 10. It's attached to Exhibit 10 that he filed in connection with the Second Amendment complaint, which is the transcript of the. I keep saying bipartisan. No, anyhow, it has two Democrats and 1 Republican commission in Philadelphia, looking at the provisional vote, and they threw out in a heavily Democratic area when the Democrats were doing more mail-in ballots than Republicans. They threw out 4,000 votes because there were naked ballots. These aren't people who are involved in fraud. There's just no evidence of it. Now,
Mr. Fox, let me, excuse me again. What is the standard that a lawyer in this position needs to adhere to in the sense of pre-filing investigation? And I'm, the record shows there's a lot of stuff that Mr. Giuliani had, and a lot of smoke and some mirrors and a lot, there's stuff that appeared on its face to be absurd, that no reasonable, rational person would rely on. Some Uber driver tells somebody else about busing in of voters from around the country to Philadelphia to vote. That's just, nobody would rely on that in filing a complaint. But some of the other stuff was a bit more credible. And you've got a situation where a lawyer is under the gun. I mean, in terms of time, there's no time really to do much at all before you pull the trigger. And is in that context, under this extreme time pressure, it seems to me that you're more there's a better chance that you can legitimately, ready, fire, aim kind of a situation, which in many respects, I think you said basically that's what they did. But with the time pressure, isn't there more leeway to do that?
well, I don't think there's more leeway. The time pressure seems to me to cut in a couple of ways. First of all, the states have procedures, as Mr. Brozos, I think, has already pointed out. The states have procedures to deal with these things on an expedited basis. That's that's one thing. If you really think there's a problem with notice and cure, invoke those state procedures and invoke them before the election. If you think there's a real problem with the barriers, do exactly what they did in Philadelphia. Hash it out in the local courts. No problem. That's what you should do. But there's no presumption that you have a right to file a case with no factual basis. And even if there's a time crunch, there's no presumption of that. And the time crunch, cuts 2 ways. One of the reasons that it's a time crunch is that it's so important to get these elections done, over, and resolved. We all know that from the subsequent events that happen. There are various deadlines in the process when the state has to certify, the Electoral College has to vote, the vice president has to accept the results. All these are deadlines, and they're important. And so, somebody should not be bringing a frivolous case to interfere with those deadlines unless there is a solid basis for doing so. So I'm not sure that the time pressure doesn't cut both ways here, but it certainly does not give somebody the right to bring a case with no basis. And I want to talk a little bit about some of the stuff that Mr. Giuliani just makes up. I mean, he told us yesterday for the second time that there were 17,000 voters in Pittsburgh who went to the polls, got to the polls, and were told, you've already voted by mail, you can't vote, or you got to vote provisional. That's what he said. Now, we challenged him on that initially, showed him what the facts were, or what the basis for that was, and he came back and said it again. I'd like to put up Disciplinary Counsel Exhibit 32 at page 33. This is the memo from Miss Freeze, which is where this allegation came from. You'll see in the first paragraph, she's basing this on some anonymous whistleblower. We don't know anything about this person other than he's a whistleblower. And then here's what she says about the provisional ballots. She says that there were 17,000 provisional ballots in Pittsburgh. She says some of them were denied, not because they were told they'd already voted, but because they were told they had already been sent a ballot, not that they voted the ballot. But Mr. Giuliani, and it wasn't all of the 17,000, Mr. Giuliani continues to say 17,000 voters in Pittsburgh showed up to the polls and found out they'd already voted by mail. That's not what it says. And those kinds of inaccuracies burble from him like bubbles from a fountain. I mean, yesterday he told us for the first time that in the voting in Philadelphia, all of a sudden there was an unexpected stop and everybody was sent home, and then they came back, and then all of a sudden the votes started spiking for Biden. Where did that come from? There's nothing in the record to support that. There's no declaration, there's nothing. That was not part of the allegations. Now, there was an allegation like that made in Georgia, which was completely discredited. But not only did Mr. Giuliani assert yesterday, with no basis whatsoever, that this happened in Philadelphia, he said it happened in, I don't know, he named a couple of other cities as well. I mean, and his pleading style and his argument style is the same thing. It's fact-free. I mean, we have tried to put into this record every single declaration that we can find that Mr. Giuliani had. But he did the same thing. Look, the first exhibit, Respondent's Exhibit 1, is 624 pages long. It's their biggest exhibit. It purports to be all the declarations and affidavits and things that they had that supported all these claims. How many times did you hear Mr. Giuliani in his testimony, or even the Respondent's Counsel, refer to their Exhibit 1? How many times did you hear them pull out one of those declarations and show how it supports that there were 17,000 voters in Pittsburgh or whatever it was? Not once. They don't rely on that at all. And they don't rely on that at all because it doesn't support what they said. Now, I've got to prove a negative here. I accept that burden. I understand that. But the way to do that is to try to put all the evidence there, including their own evidence, the declarations they came forth with. They don't support what they claimed. And that's why when you look at Exhibit 32, we went through it in some detail. I'm sure I bored you all to death with it a couple of days ago. But it's important because it's Mr. Giuliani's first response to me when I made an inquiry of him as to, what's going on here. And he sends back an explanation, a detailed explanation, perfectly, rational explanation. And he attaches to it 15 exhibits. Now, you would think these would be the smoking guns, the things that will convince you of it. And we went through them one by one. 4 of them concerned the existence of these barriers, which we don't dispute. 1 of them concerned the fact that there was notice and cure, which we don't dispute. And the rest of them are garbage. And all of this stuff is. Look at the pleadings themselves. We'll try to detail this for you in the post-hearing brief. But the pleadings are tons and tons of verbiage, citations to cases, which is not normally something you see in pleadings, link, all this stuff. They go on for 80, 90 pages. And there are probably, 15 factual allegations included in the pleadings.
Mr. Fox, what do you make of the claim that, well, I had a lot of stuff, but it's been dissipated and sent to, other people took it and we can't find it?
Well, we subpoenaed everybody we could think of. But first of all, I don't know that he said there was a lot. He said there were some. Second, if it was really important, I would think Mr. Giuliani would have been able to describe it for us. Oh, by the way, I had this one killer declaration that just showed that there was massive fraud being committed in Philadelphia by these people, these volunteers who were counting the elections, and I just happened to lose it. But we got it from 4 different sources: from Mr. Giuliani, from the Scarinci law firm, from Ms. Kearns, and from Mr. Hicks's law firm. Every lawyer who signed the complaint, we subpoenaed them all, and they put in their own version, RX1, and none of it supports any of this stuff. And maybe I'll be surprised. Maybe Mr. Leventhal in his closing argument is going to come up and pull some smoking guns out of RX1, but I doubt it. Now, let me just say, look, to bring a case like this, you got to have a basis in fact, and you got to have a basis in law. And I've been focusing primarily on the basis in fact, because there isn't any basis in fact. There also isn't any basis in law, but frankly, I don't want to get hung up too much on this. Those of us who are lawyers, we like these kinds of things, but it really, if there's no basis in fact, it doesn't make any difference. Having said that, I will then launch into a brief discussion of the basis in law. And the first thing I'll talk a little bit about is the electors and the election clause. This is just not something you raise in a 1983 civil rights case. It's a allocation of powers issue. The basic argument is that when the legislature is given the responsibility under the Constitution to establish the guidelines for voting, and the legislature generally delegates some of the details of that to the executive branch, in this case the Secretary of State. And so the argument is, did the Secretary of State go too far? Did she do things that she wasn't authorized? I guess really is almost not quite a separation of powers argument, but it's that kind of analysis. It's not a civil rights argument. It's not something you raise in a 1983 action. If you're going to raise that issue at all, presumably the legislature sues the Secretary of State and it gets hammered out. But it's not a civil rights claim, and that's why it dropped out of this case entirely. So what are the civil rights claims? All right, the equal protection claim for the voters. And I don't want to spend a lot of time on that because I think the hearing committee knows what's wrong with that. The voters sued the wrong party. If they were denied the right to vote, it was because the counties in which they lived didn't bother to notify them that they had messed up their mail-in ballot, and they sued. And they should have sued them, but instead they sued the other counties and asked that all those mail-in ballots be disqualified. The equal protection argument for the Trump campaign falls on its face, and the Third Circuit, clear on that, because they don't plead that the Trump campaign was treated any differently than the Biden campaign. Those same barriers that inhibited the Trump campaign observers inhibited the Biden campaign observers. Now, Mr. Giuliani said yesterday, well, there were some exceptions where some Democrats got past them. Not sure that was ever pled, but he also candidly admitted that in general, the Democrats, and he said it specifically at the oral argument, the Democrats were subjected to the same restraints. And therefore, and what about the notice and cure? The Biden voters in the county that didn't have notice and cure were treated the same way as the Trump voters. The Biden voters in the counties that did have notice and cure were treated the same way as the Trump voters. It doesn't make out an equal protection claim. And by the way, just to stop for one moment on the notice and cure, and maybe this ought to end the thing. It's really a footnote. I mean, the Third Circuit said that they said that they'd identified that I think something over 6,800 sticks in my mind, persons who had the benefit of notice and cure, and they said that means the maximum number could have been, let's say, 10,000. This is an election decided by 80,000 votes. I mean, it's silly.
Is there anything in the record as to why certain counties did not implement notice and cure?
No.
Yeah.
I mean, I think one could fairly infer that that there's some timing issues here, because what happened was the Secretary of State wanted all the counties to implement notice and cure, and that's why she went to the state courts, and you got that ruling that we've all seen from the Pennsylvania Supreme Court. And the Pennsylvania Supreme Court said, no, the law doesn't require them to do that. Didn't say they couldn't, said they're not required. So then, and that's the dates in the record of that opinion. It's either in September or October. Sure, so it's shortly before the election. And then she sends it out, and some people do and some people don't. So that brings us to the final claim, which is the barriers as somehow a substantive due process claim. I mean, the barriers themselves are not any kind of federal claim. What's the substantive due process claim? It depends on the existence of a massive fraud caused by these barriers. And they never even alleged facts that there was any fraud. They never showed a single voter who voted who shouldn't have been allowed to vote, or a miscounting of the vote. They alleged it. How do you try to prove it? Look at the arguments that they make. They make essentially 7 arguments, I think. Maybe I've miscounted, but I think it's 7. The first one, they cite the Carter-Baker report. It could, a statement, this could lead to fraud. That doesn't prove fraud happened. Second, they cite misconduct outside of Pennsylvania. Mayor Daley in 1960. That certainly is not evidence of any fraud in the 2020 election in Pennsylvania. Third, they cite misconduct that occurred before the 2020 election. That isn't proof of fraud in the 2020 election. Fourth, they cite some irregularities in counties they didn't even bother to sue. You remember yesterday when Mr. Giuliani pointed out this allegation about this mail carrier? It was in Erie County, not one of the defendants. Okay, not a single allegation of fraudulent conduct. Sorry, not a single fact, plenty of allegations, not a single fact of fraudulent misconduct in the 7 counties that are involved. And so what are their last 3 arguments? The observational barriers, which we've discussed, this somewhat eccentric testimony about statistical evidence. And if you look at the oral argument, it frankly doesn't even make much sense. And finally, this unspecified proof, the 300 declarations or affidavits that we've got, which substantiate all of this. None of it hangs together. None of it is proof of the kind of fraud that you would need to prove. So there's no there. This is not just a pudding without a theme. This is there's no pudding for this proof. This case is ultimately frivolous because federal courts are not in the business of taking away citizens' right to vote, which is what Mr. Giuliani asked them to do.
Mr. Fox, can I ask you, there are 2 violations alleged, 3.1 and 8.4. Is it necessary that you prove the 3.4 for the 3.1 for the 8.4 violation?
I think the answer is yes. Because if there had not been, if the complaint was not frivolous, then you wouldn't have, I mean, we've pled 8 remember, we're pleading the Pennsylvania rules here. But the law in Pennsylvania is, it's a little broader, but the law in Pennsylvania is not dissimilar to the District of Columbia in that unnecessarily burdening a tribunal is a violation of 8.4D. And you know, in DC, it's required that happen, not so much in Pennsylvania, but essentially we're pleading the same thing. And there wouldn't have been all this unnecessary litigation if the litigation had been legitimate. So I think the answer is that they are linked in that fashion. I see you have a look of puzzlement on your face.
Well, I do from something you said. Let me. So, yeah, okay. I understand. So if you plead a case and lose, it doesn't necessarily implicate 8.4.
No, absolutely. I mean, if I certainly would not take the position that everybody who brings a case and loses, but somebody who, you know, had the opportunity to raise these issues if they wanted to raise them in the state courts where they should have been raised, in a system that is designed to deal with it, and instead concocts this bogus civil rights claim and files it in the federal court and ties up the federal courts and then you know, all the way through the Third Circuit with this stuff. That's the violation of 8.4.
Mr. Fox, in line with that, one of the things that's really bothering me is, on one hand, you have the frivolous claim issue, and on the other hand, you have the zealous representation issue. And I'm trying in my own mind to distinguish this case from any other case where a lawyer brings a claim and it's tossed under 12b-6. Okay, motion to dismiss granted. And here you have conceptually, and I understand when you get down and dirty in the facts, there are significant differences. But conceptually, you have a lawyer who engaged local counsel who purported to be experts in election law, who had working with him, at least there's an inference, other lawyers in Arlington, Tensing and DeGeneva and others, who engaged an investigator to look into these claims before they pulled the trigger. So, you know, those concepts are probably represent more diligence than the reasonably ordinary prudent lawyer would have before filing a claim or complaint in federal court. And I don't need you to do that now. You can address it if you want, but drawing that line and distinguishing this case from the ordinary reasonable case is something that I'm struggling with in my mind. How do you identify one as improper and one as perfectly appropriate under the zealous representation doctrine? Does that make sense?
No, it makes sense, and I'll try to address it more thoroughly, but let me just give you an immediate reaction to that. There are many instances that we all confront every day in which we have principles that are, to some extent, are at war with each other. I mean, for example, just think about this case, these kinds of cases on their merits. On the one hand, you have the principle that every vote, you know, every citizen is entitled to have their vote counted. On the other hand, you have the principle that elections ought to be fair, and you know, that people who aren't entitled to vote ought not to be able to vote. So you've got opposing principles there. Similarly, you've got opposing principles in the free exercise clause and the establishment clause of the First Amendment. But and you have an opposing principle here too. Zealous representation on the one hand may be opposing to not bringing a frivolous case. I don't think so, but you know, one could certainly set it up. I think the zealous representation generally applies once you're, you know, conducting the litigation. I don't think it gives you, well, I know it doesn't give you the right to bring a case with no basis whatsoever. You can't say, well, my client, look, I am quite confident that Mr. Giuliani's clients wanted him to bring, you know, as strong a case as they could. But the fact that your client wants you to do that doesn't mean that you can bring a case that has no basis. If my client says, sue him, you got to sue him, but I don't have any basis to sue him, I got to say to my client, I can't do that. I don't have a basis to do it. And, you know, and are the principles somewhat at war? Perhaps. But, you know, as lawyers, we have to deal with those kinds of things all the time. And, you know, and that's what Mr. Giuliani should have done. Maybe his client was insisting that he sue, but it's his obligation as a lawyer to say, I can't subject defendants to a lawsuit where I have no factual basis to bring that lawsuit. And as I was starting to say, courts are not in the business of taking away people's right to vote. I mean, the federal courts in particular are not in that business. I mean, and the numbers, like everything else with Mr. Giuliani's pleadings, are very slippery. But let's just take the lowest number, which I think is the most favorable to him, which is 680,000. At a minimum, he was requesting that the federal courts take away the votes of 680,000 citizens of Pennsylvania. The vast majority, actually probably every one, but certainly the vast majority of whom were legitimate voters who had voted. Now, it is a perversion of the civil rights laws, laws that were designed to protect the right to vote, to use them to deprive people of their right to vote. It's never say never. So I will say difficult instead of impossible to conceive of facts that would justify doing that. I mean, maybe you could come up with evidence, or some evidence that 680,000, you know, people were bussed into Pennsylvania and voted illegally. You know, it'd have to be something like that, something as preposterous as that. Mr. Giuliani didn't have evidence of even one. Now, a lawyer of his experience and sophistication certainly should have known, and probably did know, that this case had no chance. There's an ulterior motive for these cases. It's part of a larger effort that we've all seen to discredit the results of the 2020 election.
Is that the record?
Well, I mean, I think Mr. Giuliani actually used the phrase inference. I think that's the inference that you draw when you see somebody who goes to the party headquarters the day after the election and says, where are the lawsuits? Not where are the evidence, where are the lawsuits? And then this wasn't an effort to bring legitimate lawsuits. This was an effort to discredit the election.
I object, this is not in evidence.
Well, then I submit to you that you should conclude that that's what's going on here. And
well, Mr. Fox, on that issue, isn't it reasonable? And I think somebody testified to this too. If you're involved in a heavily fought campaign, to have draft complaints ready to go in the event that facts support them. I mean, you don't want to be caught behind the eight ball doing initial research in the elections law issues, or I mean, so I don't see that quite as sinister as you might.
well,
And Mr. Hearing Officer, I was, what's going on? I was muted. I tried to object, but I don't know what's going on now.
So I don't know what the action is by overruling. Did you?
Ms. Bernice, I don't think, the only evidence I think that people have these draft complaints sitting around ready to go is Mr. Giuliani's testimony. I don't know how you draft a complaint without knowing what the facts are. Yeah, you could draft legal memoranda that set things up, and surely, you know, every campaign, every presidential campaign that I'm aware of in recent years has lined up lawyers ready to go if things happen on election day, like the barriers in Philadelphia. If things happen on election day that they have to address immediately, sure, that people are lined up and prepared to do that. But I mean, can you think of any other presidential campaigns recently where after the results were in, all these massive suits were filed? No, it doesn't happen. This is a unique thing in American history. I mean, and you know, and I think you can infer what I think what is obvious, that the purpose here is to discredit the results of the election, not to win the lawsuit. Whatever it is, Mr. Giuliani is not entitled to use his position as a lawyer to file a case without a basis in law and fact. And he's not, even if the purpose is not as improper and unworthy as I believe this one was. There was a lot of testimony yesterday about his public service. I don't dispute that Mr. Giuliani has had an extensive career of public service. And I certainly don't dispute that his conduct following the 9/11 was admirable and credible. But he throws all that away when he tries to use a lawsuit to undermine, you know, what I think is the essence of a democratic republic, that the majority rules and the minority accepts that. And I think it's important to send a message that other lawyers can't do that, that it's improper conduct and that you can't bring a case with no basis, particularly a case as important as this, that has the implications that this case has.
Let me ask you a nitty-gritty question. Under the Pennsylvania rule, is the standard of violation to violate 3.1 subjective or objective or a combination of both?
It's a reasonable person test. You don't have to prove that the lawyer, you know, the lawyer could be crazy or have a irrational belief that there was a legitimate basis for bringing the complaint. But if a reasonable person could not do that, if a reasonable person couldn't come to the conclusion that you use a civil rights statute designed to protect the right to vote, to take away people's right to vote, then that's a violation of 3.1.
And when you say reasonable person, I mean reasonable lawyer, and
Yes.
and is that a reasonable lawyer steeped in election law, or is it reasonable lawyer without any particular election law experience?
Well, you're not supposed to bring a case if you're not competent to handle it. So I think one has to assume that the person bringing the case has educated himself sufficiently in the relevant law to know, you know, what the standards are to bring these actions.
I just want to note that Mr. Giuliani is not accused of violating that rule.
I didn't hear anything that you
I'm on mute again? Oh, I said, I just want to note that Mr. Giuliani is not accused of violating another rule, which Mr. Fox has cited.
I'm not accusing Mr. Giuliani of violating another rule. What I'm saying is that all lawyers are supposed to be competent to handle the matters they're handling. And so that means that if you're applying a reasonable lawyer test, that you apply a reasonable lawyer who has sufficient education, has sufficiently educated himself in the relevant law in the area in which he's bringing a case. I mean, if I were going to bring I would be totally and completely incompetent to bring a patent case, okay? Maybe all of us. I'd be completely incompetent to do so. If I brought a patent case that had no basis in law and fact, I can't, it's not an offense for me to say, gee, I'm not a patent lawyer. So I think that's the answer to your question. I have nothing further unless the committee has additional questions for me.
I have a question based on what you just said. Mr. Giuliani, did anyone else on his team have had or have the experience in election law that understood the process in Pennsylvania and the 7 counties election process? Was there anyone else on the team?
I think that's an excellent point. And the answer is yes, at least according to Mr. Giuliani, and I think he's right on this, that Mr. Hicks and the people that were originally on the case who withdrew did have that experience. In fact, if you look at the list of lawyers in some of those pre-election cases, you'll see Mr. Hicks's name is prominent there. So clearly Mr. Hicks did have experience in election. And, so I think that is attributable to Mr. Giuliani as part of the team at the time.
And why, and maybe I misunderstood why Mr. Hicks is not available to testify in these proceedings.
Mr. Hicks, my subpoena power is limited to 25 miles around the courthouse where I'm sitting right now.
Okay.
Mr. Hicks is in Pittsburgh. I represented, and I think Mr. Leventhal will represent the same thing, that I attempted to speak with him. He wouldn't do that. The only thing I could do was subpoena documents. I do have the ability to subpoena documents, in part because his law firm had a DC office, and the subpoena is in the record. And so I served a subpoena on him there in DC, but that's all I could do.
Okay, thank you.
Is there anything in the record as to why those lawyers withdrew, other than what Mr. Giuliani said?
No.
Mr. Fox, I just have one quick housekeeping question. This action, Mr. Giuliani was suspended based on an action taken by state court in New York. Does this case now assume a life of its own, regardless of what happens in New York State?
Boy, that's like a law school exam question. So let me just kind of walk through the facts, and maybe that'll help. My understanding is that the New York court sua sponte suspended Mr. Giuliani without a case being brought by my the people who have my job up in New York. I forget the actual name. And they did that on a much broader basis than the case that I have brought, relying on things that I would not be willing to rely on, which are statements that Mr. Giuliani made, not as a lawyer in court, but he has a radio show and things like that, where I think, frankly, First Amendment issues are involved. The District of Columbia Court of Appeals rules are that there's a presumption in favor of imposing discipline that's imposed by another court on a member of the DC bar who happens to be a member of that other court's bar. And they did that. Mr. Giuliani opposed it, and they did that on that basis. So let's suppose that we go through all this process and there's a determination that Mr. Giuliani has no liability, I frankly don't know what happens in that case. I think the reality would be that time will have solved it, that New York will have come to some final resolution, because New York is, my understanding, it's just a temporary thing as ours. Will come to a final resolution, but I don't know. I can't say for sure, but given the slow pace of the disciplinary process in the District of Columbia, I suspect there will be some kind of resolution of the New York matter. And I would think that the DC temporary suspension would go away if the New York temporary suspension goes away. I assume it would. I certainly wouldn't oppose it.
So what effect would that have on the instant proceeding?
I don't think it would have any. Because that, I mean, my specification charges is different. There isn't a specification of charges or whatever they call it in New York, a charging document. But my specification charges is different than the matters that were cited by the New York court in imposing the suspension.
Okay, thank you.
Okay, anything else from the panel? It's we've been going an hour and a quarter. I would suggest that we recess until 12:30. And who's arguing on behalf of the respondent? Mr. Leventhal?
I will try, Your Honor.
All right, we will hear from you at that time, and hopefully if you guys can work out your microphone situation so you don't get yourself twisted up in knots when you're trying to speak, it would be helpful. Thank you. We'll see you in
Yes.
15 minutes.
Is this Megan? Is there someone that I should call in your office to help
Yes.
set up?
Michael Di Benedetto, he'll give you his number.
Okay. If he wants to just email me his cell phone number or whatever, I will call him.
Thank you.
Yep.
You
Opening up the breakout rooms for everyone now.
Can I
that Republican counties,
Just to let you know, you're back on the record.
equal protection applies to both.
I'm here. It's the reporter.
Thank you, Kim.
I'm complaining that I can't hear anybody and I'm muted. I'm sorry. I've tried, before we begin, have the parties agreed on the witness list, on the exhibit list? And what's been, what not been admitted? Now we can't hear you, Mr. Cameron, Mr. Leventhal.
Mr. Harrell's been handling that, but I think we have an assigned witness list now to submit to the board office.
But there's no dispute, right?
No,
There's no dispute.
That's all I want to know.
Am I heard?
Well, yeah, we can hear noise, but not really what you're saying. Mr. Giuliani, could you say something? And then my suggestion might be that you switch chairs with Mr. Leventhal. No, wait a minute. I can't hear you either. I'm sorry. Can't hear you.
Yeah, I don't know if the mic that you have, external mic, is on mute, possibly. We did hear you when we got back from break. Can you say something now so we can see if we can hear you?
Hello? Can you
Okay,
hear me?
we can definitely hear you now. Thank you.
I'm sorry. We had a switch in our technician today.
Anytime you're ready, Mr. Leventhal.
Good afternoon. Respondent Rudolph Giuliani should not be sanctioned as there is no clear and convincing evidence, which I didn't hear Mr. Fox mention at all, that he violated rules 3.1 and 8.4D of the Pennsylvania Rules of Professional Conduct. Mr. Giuliani's representation of then President Trump must be viewed in the context of what had transpired and occurred during what was a chaotic situation in a compressed and truncated period of time. I see Mr. Fox wanted to talk only about fraud here. And maybe we'll talk a little about fraud because there was some fraud alleged, but that's not what we're going to concentrate on here. We're going to concentrate on the due process, viability of the due process, and the equal protection causes of action. The presidential election was held on November 3rd, 2020. On November 4th, then President Trump placed Mr. Giuliani in charge of coordinating the campaign litigation nationally. Mr. Giuliani set up offices at campaign headquarters in Arlington, Virginia. From November 4th through his appearance in the Pennsylvania litigation, he began setting up litigation teams for Pennsylvania, Michigan, Arizona, Georgia, Wisconsin, Nevada, North Carolina, and New Mexico, and held various discussions with lawyers in various states. Judge Brand noted that attorneys for the plaintiffs both appeared and withdrew within 72 hours. On November 9th, the complaint is filed by the attorney Ronald Hicks. And if I can answer Ms. Hainsworth Murrell's, I hope I got your name right, madam,
That's what it says on the screen, although mine probably says Barry Cammons, but
That's correct. Hainsworth Morel.
okay. To answer your question, a reasonable attorney who is not well-versed in election law should use an attorney who is well-established in election law. And I point to you that in the cases that were cited in the equal protection part of the complaint and in the motions, namely Pierce versus Allegheny County Board of Elections, which was a Western District of Pennsylvania federal case, the district court found that different counties across the Commonwealth employed different standards to determine whether an absentee ballot should be counted and considered a legal vote. The court held that this disparate treatment implicated the Equal Protection Clause because uniform standards will not be used statewide to discern the legality of a vote in a statewide election. Notably, the court held that plaintiffs had standing and properly had an equal protection claim in capacity as voters and issued a limited injunction. Judge Brand did not distinguish or even acknowledge Pierce in this decision. The reason I'm mentioning that is that the attorney, plaintiff's attorney in that case was Ronald Hicks. And Ronald Hicks was the one who predominantly drafted the initial complaint. Now, on November 9th, the complaint was filed by Hicks and Carolyn McGee of Porter Wright and Linda Kearns. On November 12th, Hicks and McGee moved to withdraw, and two Texas attorneys, John Scott and Douglas Bryan Hughes, joined as co-counsel for Linda Kearns. On November 13th, the Third Circuit Court of Appeals issued Bonet versus Secretary of the Commonwealth of Pennsylvania. And I want to alert the panel that 2 days after the argument on November 17th, the appellants filed a writ of certiorari to the Supreme Court of the United States on Bonet. And that's important because that's what Mr. Ortiz said. Mr. Ortiz said if that was going to be done, there, the plaintiffs, the respondent, was perfectly allowed to say that he wanted to preserve that right to overturn Bonet. Now, on November 15th, 2020, plaintiffs filed the First Amendment complaint with attorneys Kearns and John Scott. Defendants filed motions to dismiss on November 16th. Later that evening, Linda Kearns, along with John Scott and Douglas Hughes, moved to withdraw from the litigation. Judge Brand granted Scott and Hughes' motion as they had only been in the case for less than 72 hours. Judge Brand did not grant Kearns' application as she had been one of the original attorneys in the litigation. An oral argument was scheduled for the next day on November 17th. And Judge Brand wanted to have someone to be able to answer the questions as indicated in the oral argument. I'm looking, just give me 1 second here, I'll hear it. Also on the 16th, Mark Skorinsky entered his notice of appearance for the plaintiffs and requested to postpone the previously scheduled oral argument and evidentiary hearing. The continuance application was denied, cited by the court as the emergency nature of the proceeding and the approaching deadline for Pennsylvania counties to certify the elections results on November 23rd. On the morning of November 17th, respondent made his application, filed his application to appear pro hac vice to the court and entered his appearance on behalf of the plaintiffs. Argument was held on the First Amendment complaint, and Judge Braun noted that he was glad that Ms. Kern was there to answer his questions and wished she stayed in the case as respondent and Mr. Skorinsky were just getting settled into the case. And that's noted at page 168 of the Disciplinary Counsel Exhibit 8. Respondent and Mr. Skorinsky stated their intention to file a motion for leave to file a second amended complaint. Judge Braun stated that he had not decided this matter. So at that point, Judge Braun did not think that this was a frivolous complaint. He hadn't even decided whether it was going to be dismissed. And that's on page 159 of Exhibit A. The court noted that the respondent's client was unpopular, and so was his cause, but also noted that representation was warranted. And that's on page 161.
Well, in his opinion, didn't Judge Braun call the remedy that was sought unhinged from the underlying right being asserted? Doesn't an unhinged suggest that he thought it might be frivolous?
Well, I just want to bring your attention that when Mr. Giuliani and the lawyers brought the motion for a TRO, they only requested to maintain the status quo and not so that they would not certify the election. And he intended to prove, if given an opportunity, a hearing was originally scheduled and he canceled the schedule, Judge Braun. And he was given the opportunity, he would try to prove the allegations and achieve one of the remedies, including whatever the court thought was proper, maybe a new election like Marks v. Stinson.
I thought that you were suggesting, because he didn't call the claims frivolous or sanction Mr. Giuliani, that Judge Braun viewed them somewhat favorably. But it seems to me that calling them the remedy application unhinged, and then he said, one might expect that when seeking such a startling outcome, a plaintiff would come formidably armed with compelling legal arguments and factual proof of rampant corruption, none of which was brought before him.
Well, that's what he's talking about in the dealing with the fraud allegations. But as I said, I think Judge Braun made, and Mr. Ortiz made big mistakes in the due process and equal protection realm. And if I may.
Can I ask you a question, Mr. Leventhal?
Of course you can.
Talking about due process and equal protection, the two plaintiffs, Henry, was it, and Roberts?
Yes, sir.
They're not an attempt to get their vote counted rather than to disenfranchise, 680,000 people.
Well, that really was under a voter dilution standing. And they couldn't get any remedy if they sought to sue their counties. I know Mr. Bernius had brought that up earlier. They couldn't get any relief by suing their own counties. So in Reynolds versus Sims, the Supreme Court explained that the right of suffrage can be denied by a debasement or dilution of the weight of a citizen's vote just as effectively as by wholly prohibiting the free exercise of the franchise.
They couldn't get relief from their own counties because they didn't sue them, obviously. And what relief did they expect to get from the counties that they did sue? I don't understand. They sued them as defendants. What did they want those counties to do vis-a-vis the individual plaintiffs?
Well, they wanted to have the votes they wanted to have, it's really an equal protection argument. They weren't allowed to cure, and the other counties, in the Democratic counties, you were allowed to cure. And I think we just lost, and that's an equal protection argument, but I think he was talking about standing, if I'm correct. Is that correct, Mr. Broses?
They sued these defendant counties. There's no indication that they ever set foot in those counties. What relief were they going to get from the defendant counties?
They were trying to show that there was an equal protection argument, that different counties were treating the way the votes were counted differently in those 7 counties as in the Republican counties. And there were averments in the complaint stating that. And I can
I
cite,
understand that, Mr. Leventhal, but what, they sued 7 counties and 7 boards of election. What relief did they expect to get from those counties?
they expected that those counties who did notice the cure, either those votes should not be counted because it was contrary to law, who did notice the cure, that was contrary to law because a reading of the Supreme Court decision where, see, and I think Mr. Fox got that case wrong. What happened in that case, the Democratic Party sued for notice of cure being mandated. The Secretary of State was the one who opposed that. She opposed that. She didn't want to have a mandatory notice of cure. So once there's not a universal notice to cure throughout the state, it runs afoul of Bush v. Gore. It runs afoul of all of the equal protection cases that were given to you in my in our memorandum today, but also cited.
Can you name one case, state or federal, in the entire history of this nation where a voter who has properly been denied his right to vote can obtain the disqualification of thousands of other voters who properly voted? Is there any case in law or equity that has given that relief?
No, but what I'm saying is that if everyone has to be treated equally, then we either.
You don't have any precedent for that extraordinary remedy.
Well, let me say this. That doesn't mean, look, I had Mr. Ortiz was on the stand and you were so nice to let me ask him 2 questions. And in a double jeopardy situation, the Supreme Court reversed itself when setting precedent within 2 years. In a criminal law scenario, within 24 years, a decision was reversed in how to handle hearsay. And it changed the contour, never before, it changed the contours of criminal litigation in terms of. So this
claim was based on the anticipation that the Supreme Court would reverse itself. And what opinion did you expect it to reverse?
You're saying it's without precedent when he was trying to make precedent.
But he's trying to make precedent, but I mean, the history.
There's 2 ways to look. I'm sorry, go ahead.
But the history since all the voting rights case was to, and especially equal protection, to expand and protect the right to vote.
So then are you saying that my client, Mr. Giuliani, did a disservice to his client by not suing all of the counties that did not permit notice to cure? If that's so, then he didn't do enough for his client. But it's definitely not frivolous. He made a mistake. It's definitely not frivolous. If you're telling me he should have sued all of the counties that didn't allow notice to cure because they treated these people unfairly, then he made a mistake. He did a disservice to his client. And if he could have gotten those votes counted, that's a mistake. That's not frivolous lawsuit.
But you will acknowledge that in elections, different counties implement different procedures.
But that's not, that might be true. That might be true. But if you give me a moment, because you asked very good questions, and I want to have a good answer for you. All right, notwithstanding the language in Pennsylvania Democratic Party versus Bookvar, clearly indicating that whether to provide notice and cure is a task addressed to the legislature, let's assume you buy what I would I think a reasonable interpretation is that notice of cure cannot be done. All right, but let's assume you say that it's up to each individual counties, that such a procedure resided within the discretion of each county board of election. Even if Judge Braun's interpretation were correct and not precluded by the electors and elections clauses, that reading of Pennsylvania Democratic Party versus Bookfar would implicate the equal protection principles in Bush v. Gore. Importantly, respondents' arguments in this case did not necessarily hinge on the theory that any non-uniform treatment between counties renders an election process unconstitutional. As a matter of fact, in Bush v. Gore, the
I'm
question
sorry,
is not.
Mr. Leventhal, what are you reading from? What is that?
I'm reading from my notes for the argument. The
Oh,
question
okay.
is not whether local entities in the exercise of their expertise may develop different systems for implementing elections. Instead, we are presented with a situation where a state court with the power to assure uniformity has ordered a statewide recount with minimal procedural safeguards. That's what happened here. The Secretary of State send it out, do it if you want, don't do it if you want. When a court orders a statewide remedy, there must be at least some assurance that the rudimentary requirements of equal protection and fundamental fairness are satisfied. That wasn't done here. What you're saying is that my client should have sued other counties and he might have won the case. That's his fault, maybe. But I don't agree with that. I'm sorry.
No.
No, and if I may, I know I alluded to that one case where Hicks was involved in, but there are two other cases cited, and Judge Brand, in due respect, and if he were here, I would say that with due respect, he got it wrong. He got it wrong on the equal protection. And
Is there any collateral, is there any collateral estoppel effect in this case? From the fact that Judge Brand reached his decision and the Third Circuit affirmed? I mean, your client was a participant in those proceedings. So how can he challenge the rulings at this point?
well, I think we can argue whether a reasonable person can make that argument. And when as Mr. Fox said, a reasonable attorney can make that argument without being frivolous. And I find it interesting that Mr. Ortiz, who was a scholar and a professor and had this case for over a year, didn't know that Macinus was reversed, did not know that there was.
I was just asking about and responding to your comment that the Judge Braun in the Third Circuit got it wrong.
Well, if our client argued something which wasn't appreciated by the Third Circuit, and the Third Circuit basically said, I think the part of their reasoning was undue delay. They agreed with Judge Braun. So that the rest is dicta about, I mean, that's what they based it on, undue delay. And they also thought it was without merit, but I think there was merit. And that's what I'm saying. Judge Braun misinterpreted Townley. And he also, Macinus was reversed. And that was overlooked by the Professor Ortiz. And I thought it was interesting that every time Mr. Kamens asked Mr. Ortiz whether he was familiar with that case or this case, he didn't know it. But when Mr. Fox asked him, he knew it, but he had this report for over a year to look at the Braun decision. All right. So,
Mr. Leventhal, do you think in a situation, a case where a lawyer brings a lawsuit basically seeking to undo the election of the President of the United States, at least in part, at least undo the results of a statewide election, don't you think there's an enhanced duty to investigate before filing a complaint seeking that remedy?
now, may I ask you that you're aware of the time frame, right? So this is a
I
very,
understand, I'm well aware of the time frame, but
And-
even
and he
under, I mean, and if you either agree with that or not, and what I would like to know is if you agree with it, what investigation did the plaintiff did the respondent do to verify the stuff, the information that he was being given?
all right. Now, you heard when Mr. Carrick testified, he didn't know who gave him that. There were a lot of investigators out there. Ms. Freeze, who was an attorney, Mr. Giuliani was asked what other information did he forget about? Well, he forgot about freezes, which Mr. Fox had provided.
Carrick testified, gave your client a bunch of stuff, and he had no idea whether it was true or not.
He had 200.
And so under those circumstances, is he entitled just to take stuff from an investigator because he's called an investigator, not determine whether there's any truth to the contents and just rely on it to file a complaint seeking undo an election?
He interviewed a number of people himself, and also we had
Where is that in the record? Whom did he interview?
Well, he said he testified to that in the Braun Mercer. All right, please. And also, the reason why Carrick didn't know who gave him this information, there were a lot of investigators out there. It wasn't just one. It wasn't just Bernie Carrick.
Mr. Leventhal, Mr. Giuliani did say he spoke to Mr. Mercer, and in fact, there were 2 affidavits from Mr. Mercer. What I'm struggling with is Mr. Mercer testified before the Supreme Court, who deemed him a credible witness, and said that, and Mr. Mercer said his observation was not obstructed in any meaningful way.
Listen, I don't think he testified in the Supreme Court. I don't think they have witnesses in the Supreme Court. I think what happened, I think the Supreme Court took that he was in the room as an ability to observe. And if you look at the dissent, they said that's not meaningful. And that's what this 5-2 in the room, and you heard the room described.
But the majority.
Yeah, that's what they said, but doesn't mean he's observed, because the statute says you have to be present when the ballots are opened, counted, and recorded. No one was present when what we know what present is with our eyeballs watching it. Now, the question was—
That leads me to another question then, as long as we're on that. What is the role? What do you see the role of a poll watcher to be?
Well, people in the campaign as well as poll watchers are allowed to be there. Okay. So let us assume that something's not dated. And first of all, let me start from the beginning. We have the envelope and they're separated. These people were not present for 6 days when virtually all the counting was done. The outer envelopes were separated. They had no way to challenge whether there was any problem with the outer envelopes at all. It has to be dated, has to be signed, and the address has to be on it.
But
So
they can't challenge. Can they challenge a ballot?
They should be able to challenge an individual ballot. Sure. They should be able to challenge an individual ballot. Absolutely.
Did the Supreme Court of Pennsylvania say that they didn't have that right?
Well, they said they don't have that right, but I'm telling you that
So what's the basis on which you say that they did?
well, that's why you have to go to federal court. And if you say there's no ability to observe, and if you have no ability to observe, then you have to go to federal court because you can't make any of these challenges. And I think that
If you lose on a state election issue in state court, you go to federal court. Why? It's a
Well,
state
first of all, we went for due process and equal protection on the notice of cure being treated differently in different counties. And also the observational being different in different counties. And that's why we went to federal court. Now, I know Mr. Fox wants to talk about fraud, but there's viable equal protection and due process arguments. And I'm not going to go into the law anymore, but I've laid that all out in the document that I filed today. And regarding the remedy, there are cases where they overturned an election. Now, I understand this is a presidential election and you're saying that's without precedent. Mr. Bernius, this election was unprecedented. There was 2,650,000 plus ballots voted by mail or absentee ballot. 2,650,000 absentee ballots. So this was an unprecedented election, never happened before. There was almost 900% more absentee ballots than voted in Pennsylvania in the 2016 election. So this was unprecedented.
And it was combined with the COVID pandemic, which also threw some uncertainty in the processes. So you can anticipate that there are going to be glitches and hiccups.
But it doesn't mean,
I'm
sorry, but it doesn't mean you shouldn't have observers and what's in the complaint is that in Republican counties, they let them go closer. And you heard Mr. Lewandowski testify that despite the court order, the elected, now I'm a Democrat, but the elected Democratic sheriff would not let them go within 6 feet before it was reversed on November 17th. So that's from November 5th through November 9th, even though there was also a settlement order. They were not allowed to go closer than the court ordered.
An anecdote about an individual not being allowed in until he got credentialed is one thing, but how do you expand that to justify undoing the election?
Well, I'm not saying undoing the election. One of the things that could have been done is a new election. And he asked the Wisconsin Supreme Court in a 4-3 decision, which I cited in the papers that I'd given you, when they were challenging, asking for a drastic remedy in Wisconsin, 3 judges pointed out that they also asked for further relief as the court deems equitable, similar to what was asked for in the second amended complaint. And they thought that was fine.
And I may be wrong on this, correct me if I am, but didn't the second amendment complaint also ask that Mr. Trump be declared president? Or words
not in the relief. It might have been in a paragraph, but not in the relief that was requested. Not in the the last page. And I know, I said it. So if you look at the prayer for relief, it was not in the prayer for relief. It was mentioned in the complaint. So I just want to point out that there were cases enjoining, and I'm not going to cite them for you now. They're in my submission. Enjoining defendants' vote count and ordering new election. I cited an Arizona case, Florida case invalidating election. And there was a Maine case, which is kind of interesting. In any event, there was a valid equal protection and due process. Do you want me to go into the law at all on that and how this applies?
No, not unless you think it's important.
Well, it is important, but I gave it to you already. But I just want to mention that Mr. Giuliani, and I'm not going into fraud, I'm saying there's a viable causes of action for fraud and due process. A reasonable or equal protection, I'm sorry, not fraud, equal protection and due process. And fraud is a red herring here. There were some allegations in fraud, and I take issue with the fact that Mr. Fox says there were no allegations of fraud. In Center County, a poll worker, this is paragraph 129, reported that persons appearing at the polls and admitting they were New Jersey voters rather than Pennsylvania voters were nonetheless provided provisional ballots on which to vote. And there were other allegations throughout the complaint like that. So I don't want to belabor the point. You're free to look at the complaint, but there was a viable due process and equal protection argument that they were treated differently in ability to observe, differently in the notice to cure, which is key. The notice to cure is key. If we don't know how many people voters were denied notice to cure in those Republican counties, then we can't be certain that the election might not have been changed. And I'm not saying it would have been changed, but I think that had to be explored. It had to be explored by the campaign, and it was a viable argument. And it was definitely not frivolous. If you give me a moment, please, if you have any more questions, but just give me a moment.
Yeah, just following up on that, was it ever pled that the number of votes in the counties that did not implement notice and cure should be discerned? I don't remember that at all. I thought it was the 7 counties, but not the counties that didn't implement.
Well, in there, I think there were allegations that the Republican counties thought that the law required them not to implement the notice of cure. And that's, and I'm saying to you, this is my argument, that unless you know how many people were denied the notice to cure, you can't be certain that the results would not have been impacted. I'm not saying it would have been impacted, but that's something that should have been explored at a hearing or trial.
But it wasn't. I mean, it wasn't at any
It wasn't, because he wasn't given an opportunity. Now, they didn't give the Republican counties because the Republican counties followed the law as they saw it. And that's the problem under Bush v. Gore and the other cases that I've cited. That if you have different ways of doing things across the state, as the Pennsylvania Supreme Court stated, that only the legislature could do notice of cure. But even if you interpret it that you could, or you may, or you might, that's definitely an equal protection under the case law. It's not just Bush v. Gore. It's the 2 other cases that are cited by Mr. Giuliani.
Mr. Leventhal, how many counties are there in Pennsylvania?
I really don't know that. I'll have to look that up.
I thought
I will. How many counties in Pennsylvania? We'll look it up right now.
I think it's 67.
That's what I thought. It was in the 60s.
Okay.
And there were 7 counties that you alleged as the defendants. Are all the other counties, the 50 plus counties, Republican counties?
No, but listen, we brought a voter dilution standing argument. And I think the voter dilution, if you look at what all right, give me 1 second.
How many Republican counties allowed notice and cure?
No, we don't believe any did, but I'm not sure. But I don't believe any did. I'm not swearing to that under oath, but we believe that none did.
And how many Democratic counties did not implement notice and cure as well?
Well, we believe that Allegheny and Philadelphia did, where most of the Democratic votes occurred, and in these other counties that were named did do that. Now we believe, and a reasonable interpretation of the Bookvar case is that it was not allowed. But even if it were allowed, it was up to each individual county, as you had said, Mr. Brosa, that you had said that shouldn't the counties be able to do what they want? That's violative of equal protection. And all right, so just give me 1 second, please. That even if this were done, it's a violation of equal protection under the case law. And it's Pierce versus Allegheny County Board of Elections. It's Shafaros versus Board of Elections, a 9th Circuit case. And it's Bush v. Gore. That is clear. They can't have 2 different systems of counting votes. And that's also a voter dilution argument, giving them standing. And it's articulated throughout their papers, and it's further expounded in the papers that I've given you. So I don't want to go into the law with you on that, but we could. Yeah, and I just want to point out that if you have any doubts, whether it's more likely or less likely, the burden here is clear and convincing evidence that there is no non-frivolous cause of action in this complaint. And I submit to you that there is a non-frivolous causes of action for equal protection and due process on the notice of cure. And I submit to you that there is a due process, non-frivolous on both of those claims. And I also submit to you that one person having standing is enough. And I've cited to you in the papers that I've submitted and given to Mr. Fox that the one plaintiff rule is applied with considerable frequency in more than 24 Supreme Court cases. I cited a law review article for that. And I also want you to know that the problem of equal protection in election processes generally presents many complexities, and that's Bush v. Gore. And we have many complexities here. The mere fact that a legal position is creative or contrary to existing law does not make that position frivolous. Existing law often has ambiguities, and even if it is clear, there is always the potential for change.
Mr. Leventhal, do you have any authority for the notion that one non-frivolous claim in an action is sufficient to defeat a 3.1 charge for other claims? In other words, if there's 3 claims in an action, one of which is frivolous, isn't an attorney responsible for making that frivolous claim, even though he's made some non-frivolous claims?
May I say to you that we never made a cause of action for fraud. We've only made due process, the electors clause, equal protection. There were 7 counts, and I'm going to look for my summary of the counts in 1 second. They were just here. There was not one fraud cause of action, not one. And I know Mr. Fox wants to make this all about fraud, but I won't engage him in that. I can tell you that there are sprinkled throughout the complaint allegations or averments that fraud had occurred, but there was no cause of action sounding in fraud. And I submit that all the 7 causes of action that were submitted were non-frivolous. Do you want me to summarize what the causes of action were in the second amended complaint? I'm looking.
I don't think it's necessary, but if you do, you can.
Well, I just, as long as we're in agreement that there was no cause of action for fraud, I'll just stop right there.
I think the complaint will speak for itself.
Thank you. I just wanted to remind you that there was no cause of action for fraud.
Mr. Fox, do you have any other questions from the panel?
No,
Mr. Fox, you have a response?
I will be very brief. The reason there's no fraud count in the complaint is because fraud in a state election does not make out a violation of federal law. But there is absolutely no way that a substantive due process claim can be made under Section 1983 without something like fraud that deprives voters of a fundamental right, the right to vote. Substantive due process requires that you identify a fundamental right that is being taken away from the plaintiff without reason, arbitrarily. And, putting up barriers to protect people, to make sure that people social distance isn't that. And encouraging more people to cure their defective ballots isn't that. So, the red herring here is the argument that this case is not about fraud. That's all I have, unless there are any questions from the panel.
Thank you, Mr. Fox. All right, the hearing, the liability phase of the hearing is over. We will now adjourn to go into executive session to discuss whether or not there's been a preliminary finding. Under the circumstances, because the respondent filed the legal memo this morning, I will give disciplinary counsel till next Wednesday to file a response to that memo if you so choose, Mr. Fox. And I would ask the parties to hold open, since we had anticipated, we booked 2 weeks for this hearing. I would like the parties to hold open next week, December 15th. In the event that there is a preliminary finding made, we may reconvene, depending on whether anybody wants to offer evidence or oral argument on sanction. Mr. Leventhal?
I just want, my client may have another court matter on that date. Could I just check that out, please? I'm just going to check it out. It might not be a problem, it might be. And Mr. Bernius, thank you for keeping your word that we'd be finished by 3. Thank you.
Sure. But let me again, I want a date, an adjourned date that people.
No,
put
he's
down
looking at his calendar right now.
in case.
We're fine. The 15th is good.
So whether we, again, that's only assuming there's a preliminary finding made.
Right.
And then if the parties want to reconvene, that would be if you have documentary evidence, exhibits for mitigation or aggravation, those can be submitted. We don't need to reconvene. Or if you have witness testimony, we will have to convene. And if you want oral argument, we can convene as well. But that's up. Think about that, and we can. We will issue an order between. Well, when did I say, Mr. Fox? December. How much time do you need to file a responsive brief if you do file one?
I have not looked at it, Mr. Bernius, and I don't know, but you've just freed my week, so I assume I'll be able to get it within the deadline that you just mentioned,
Okay, so
which I forgot, frankly.
if you could, why don't we move that to can we move that to the 13th? If you're gonna file anything, file it by then. And we'll notify the parties on the 14th, whether we make a preliminary finding. And then if we do, we'll determine whether we go ahead on the 15th. Does that make sense?
Fine. And the 15th, if God forbid there's a sanction, we will have one witness.
Okay,
What time on the 15th if we reconvene?
I'll make it 9 a.m.
Okay.
Okay,
Contingent.
Mr. Bernius, I have told the Respondents Council before, and I'll tell them again, that I am not going to object if they submit letters in lieu of character testimony. So I'm not going to object to that.
That may help. Anything else before we adjourn? Actually, I'd like to go off the record before we all leave, but anything else on the record at this point?
Nothing for me.
Okay.
nothing
Let's
for me.
Let's go off the record.